Hey Jordan, how you going?
Hey Arch, I'm good. How are you?
I'm good. I'm excited. It's our first chat for 2022 about all things digital policy and privacy and security. It's great.
Indeed, after a long hiatus, there's much to talk about.
There's a lot. Yeah, yeah.
Yeah.
Notably, I guess one of the ones that have been in committee this week and in the press around our government's mission to purge the online world of trolling behavior. What's been going
Online
on there?
trolls. Yeah, it's a good one, right? We talked about this a bit last year, right? The PM's online trolls, social media anti-trolling bill was introduced late last year, and it's been gone through a round of discussion in committee. And so there's a bit, it's back in the news this week, and there's just some great discussion about it that we wanted to touch on, right? So background: the bill, it's called the social media anti-trolling bill. It would essentially, it's a bill designed to enable people who have been defamed online by anonymous posters to identify who was behind that post. And it also kind of reverses the High Court's decision in Dylan Voller case that administrators of social media pages can be held liable for defamatory comments posted on their pages by third parties. And I mean, the high note of the committee hearings this week was really like everybody at the committee lining up to recognize that the social media anti-trolling bill is not in fact about trolling at all, and is very much purely about assigning liability for defamation and for enabling defamation actions to be brought where otherwise they couldn't. You had Noel Martin, who's the WA Australian of the Year, who making that point. You had the e-safety commissioner, in fact, making that point, knows a lot about trolling and made the point that this was not, in fact, about trolling. You even had the Attorney General's Department admitting under some good questioning by Watts that it's not in fact a bill about defamation at all. Did you catch much of that? Did you enjoyed watching that or
I
hearing
I
that, I
did. I
imagine?
mean, it was incredibly awkward, but also it's somewhat enjoyable. I mean, I mean, it's a bit of an issue when you've got these complex pieces of legislation and you take them to committee and you can't get past the title. Like there's so much.
Yeah.
There are lines and lines of complex kind of
Yeah.
regulation to wade through, and really like we're not past the first post, which is, does this title actually reflect
Yeah.
anything close to what this bill is about? And it was
It,
just remarkable to see kind of I saw someone say it was like a Clark and Door sketch. That's what it was like. It was, sort of this roundabout conversation about how the title
there's
does not reflect what's
that
in.
is that discussion. Tim Watson, the Attorney General's Department representative, is just classic. It really is classic, like Clark and Door. So would you say this is about trolling or defamation? Well, it's a product of the government. Yeah, very entertaining to watch.
Yeah. Well, I guess, I mean, the serious takeaway, which is a bit more depressing than obviously the levity that it brought, was, I mean, it is depressing that there's such a sort of misapplication of what is a concern about a very serious issue, which is sort of online safety. I mean, um, and it does feel, it's hard not to be cynical. It's hard not to sort of say, well, we're taking this area of concern, which in the PM's own words, the bill is about protecting Australians online, when
Mm.
in truth, as we've heard, many people say in committee this week, it's not actually more broadly about online safety or the safety of people who are subjected to trolling. It is about enabling certain types of people to be able to bring defamation action,
Yeah.
and also, frankly, enabling responsibility to be sort of pushed away from the larger media companies for defamatory comments, which is what the outcome of the Voller case was, which is what this kind of bill sort of set out to redress, as we discussed previously. So that part of it is, I think that part of it is sits uncomfortably and is disappointing. It's that this is an area of public public concern, and something we do need to reckon with. And there's this sort of Trojan horse aspect of like, well, we'll call this bill this thing that's going to tackle that issue, but in reality, we're just going to address this very, very narrow interest and narrow issue.
Yeah. Absolutely right, and it's really good to see that being called out. There's been some good journalistic coverage of it, and see it being called out in committee as well. That and a lot of the rhetoric, the descriptions of the bill when it was first introduced was, along those lines, right? Where we're battling online trolls, we're protecting Australians online. It's all about safety, and it's just not. It's all that's all just a lie. It's about a very tightly constrained use case. It's not going to improve the quality of public debate at all. It's just going to, as you say, shift liability and give well-resourced litigators a leg up, I suppose.
Yeah.
Which sorry.
No, I was just going to say, and that's really a great point, because there's kind of the two things there. There's this fact that they're sort of, masquerading under this false title of a bill that's tackling trolling and is really about sort of unmasking certain people to support defamation. So there's the misapplication, but then there's the fact that even with the right title and even accurately described and promoted, it's not a great. There's a lot of criticism about this bill and its effectiveness and what it actually seeks to do. So, this idea of people having to, be unmasked and not be able to be anonymous online has been found not to contribute to a less toxic environment. It's been tried in places like Korea where it's not been effective, and if anything, it has contributed to adverse effects like preventing influential figures from being criticized legitimately, because there is now this this chance that they can be defamed by people with deep pockets, and so legitimate criticism becomes silenced, and
there's
then
a chilling effect.
There's a chilling effect, and vulnerable and marginalized people that want to participate online and do so because they can be anonymous and speak more candidly and connect with people around their experience, can't do that anymore because they can't be anonymous. And so there's that as well. There's the fact that it is not actually seen to be a particularly good bill either.
And even if you just accept that it's about defamation, it's it seems ill-conceived there as well. There's a great submission, quite damning submission from the Law Council of Australia, who points to this like many years long work and consultation in developing model defamation provisions and a model law around defamation covering intermediary liability and all these things, which this proposed bill just skates straight past, takes no notice of that, and proposes this kind of patch solution. It really is a bizarre and like ill-conceived. But I mean, I want to come back to this question of like the issue of taking something that people are genuinely concerned about, kind of trolling and toxicity online, and pivoting it into using that public concern and political capital that's in that issue, and pivoting it into just a use, a reform that is vaguely related and maybe close enough in the public perception that you can get away with that argument. Because it seems to be, it's a common tactic. We saw that with the, you were highlighting that with the news media bargaining code, right? That with that, where you see also this kind of political maneuvering of an issue, platform dominance, dislike of big tech, being like pivoted into a a really focused, result for only a few parties that doesn't actually address the big concern. And for me, there's a real concern that like we're going to spend all that political capital and we're not going to have actually addressed any of the problems. People are going to be tired of talking about trolling, right?
Clearly, I think, and it feels to me also that, we're in a bit of a moment now as well, where there seems to be a bit of focus and a bit of impetus for legislation and for regulation in this area. We are seeing lots of bills, and I've read people from sort of, civil society groups like digital rights groups talking about the number of submissions that are due at the moment and that are in play. And so I feel like there's a moment in time potentially where we're starting to wrestle with these issues and wanting to kind of, deal with them, from a regulatory or a legislative sense. And I would really hate to think that we're squandering that opportunity with all of these little misapplications where we've seen, as you said, the news media bargaining code, which again, like picked off sentiment that, where that, that the big social media platforms are, maybe not acting in the best interests of, social good, and applying that to, media publishing as a sort of narrow thing. And then this bill around, there are some legitimate issues. There's some real things we need to deal with, and the cynic, the cynic in me says, well, this is like deliberate, and there's like the government is capitalizing on the opportunity to kind of meet these narrow interests. But then maybe a more favourable interpretation of that is just sort of a lack of kind of will and focus and competence and clarity around what needs to be achieved. And the Privacy Act's being reviewed at the moment, and we want to get that right. Like there's a lot at stake, and so these things are quite dismaying.
And I really liked in that context, right? I really enjoyed the committee hearings focus on the title. In that context, to be able to say, and I think we need to get better at doing this as like, ourselves, but also, kind of civil society or people having input in these things more broadly, is to say, well, actually, you don't get to use the word trolling. This is not about online safety. You don't get to hook into that vein of public opinion or concern. You don't get to use that word. This is about defamation. Let's be very clear. I think that's a lesson. It's a really hard thing to do with some of these proposals, to really, focus it down to, well, what is this actually achieving? Is this even about the thing that, we're all concerned about?
Yeah.
Anyway.
Well, let's hope that, the takeaways are there, that, there's a bit of a sting and a bit of embarrassment from that kind of discussion, and we get to better bills with better titles.
We'll see how it progresses, right? I wonder if they'll just rename it. Yeah. Anyway.
So I wanted to sort of shift us on to another topic. It was the OAIC's determination over the course of the week into the way the Australian Federal Police has been using Clearview AI, which is the notorious facial recognition tool. Can we call it that? I think we can. It's fairly notorious.
It is. Yeah.
So
globally notorious.
Notorious. So we of course had last month the OAIC had a finding specifically against Clearview AI itself, to find that the tool itself and the company itself was breaching privacy rules in the way that it was collecting biometric images, and in the way in which it was using them. Then the the UK Information Commissioner had a very similar finding with some fines attached against Clearview AI. But we also had the OAIC flagging at the time that they're also looking into not just the tool, but how the AFP have used it, and whether that kind of passes muster and is okay. And that's the ruling that we've had this week. And the AFP has found that the OAIC has found that the AFP breached privacy rules in the way that they used the tool, and they hadn't properly assessed the risks. Specifically, they found that it was members of the AFP's led Australian Centre to Counter Child Exploitation, which was at fault here. And basically what they were doing was using a free version of the tool, a free trial of the tool, and uploading kind of images of facial images of victims and people of interest in these cases. I just want to throw this to you and just get your reaction.
I am just so gobsmacked. First of all, I found this like utterly shocking. And I'm a little bit disappointed that there hasn't been more media attention or more outrage at this, right? Because I mean, maybe it's a slightly in the weeds privacy compliance, security compliance kind of thing, but the idea that cross-force AFP-led team focused on the most awful crimes by the most awful people and the most vulnerable victims could think that it's okay to upload photos of victims and persons of interest to a free web service without doing any privacy assessment, without doing any, like, put aside the risks of facial recognition, for example, but this is a random service on the internet that's no better than than any other that you can see. Like, no assessment's been done. Where is this being stored? Who can access them? How long is it going to be there for? Who else is monitoring this service? Like it's stunning to me that would be done without, that there were no processes there, that there's a culture there that seemed to think that would be okay without doing any kind of assessment or analysis. What other online services are these photos floating around in? I mean, who knows, right? They don't know. They don't have a central process for managing this.
Yeah, well, that's a great point, because when when Clearview, when the ruling came out against Clearview AI, that got quite a lot of press, and I think I used the word notorious, but there is a sort of a focus on Clearview AI in the kind of media, and so an adverse finding against it gets a bit of buzz and a bit of press. But at the time, I remember you and I discussing and saying, well, that's only part of it. We really need to kind of wonder why the AFP is using this at all. And it's great that the OASC are looking at it. But to your point, what if it's a less notorious service? Would we even hear about it? I mean, what else are they doing? I mean, the fact that mindset and that culture exists for something that's less high profile, but equally kind of loose around kind of privacy protections, God knows what's going on.
Yeah, I found it tremendously disturbing and tremendously disappointing. I mean, we can get into the discussion about facial recognition, and we talked about this in the context of Clearview, right? That this is all, they're broadly just like hocus pocus. They don't really, they're very flawed in terms of their accuracy, the ways that they the opportunity for bias or for false identification, and opportunity in the hands of a police force to really lead to really significant negative outcomes to people who are over policed or falsely identified for whatever reason. We can get into all that, but like in the context of this AFP finding, I think that's almost irrelevant, right? Like they didn't even do step one is this a legitimate service, and is it a safe custodian of the data? Step two, is like, I'd like to see them do both of those analyses, right? But they didn't even do the first one, which I see as like very fundamental, very basic. I mean, we were talking the other day, I want to hear you say it again, about the kind of culture or the kind of attitude to information that leads to that kind of thing.
Yeah, because I think, like you, I was just trying to wrap my head around, like, how do you get to a point where you use this information in this way, or and I was just trying to understand, and it felt to me like, it really comes down to like a, sort of almost like a philosophical attitude to information, and also, the meaning of information it changes in different contexts for different people. And so it's like, you've got images that are, pertaining to victims of, the most horrific horrific traumatic incidents. And is the person who's got custodianship of that information, are they thinking about it in that context as as a piece of information that has a human attached to it, that kind of speaks to an experience of harm, and then brings to that all of the kind of thought process around protection of that person and protection of that data and protection of that and limitation of harm? Or are they seeing it as a piece of useful information in the service of an investigation? Is it the utility? Is it a piece of information that has utility if it can be used to support a particular end? And it really feels like, to me, it's like, if you're operating in that second context, you're far more likely to go, well, let me put it into this tool which is all powerful and has some great commendations about what it will help me do in terms of a law enforcement investigation, versus if you're in that first space and you're thinking about information as a sort of having a deep connection to someone's experience and the need to then protect it. And that kind of can be broadened out, I think, to just generally how we think about privacy and any piece of personal information, is that often we as individuals we feel something when we hear that information has been used, because it means something to us, versus maybe an organization that isn't thinking that way and sees it as a means to an end for more targeted advertising or something like that.
I think that's such a good point. And you do see it. It's the source of a lot of things going. A lot of bad data decisions, right? Is you see people and organizations getting tied up in the utility or the instrumental value of the data or the service, and not thinking, not being attached, losing connection to what the information means and the humans that it's connected to. And I think I can just see, you can, I mean, maybe I'm putting too much to it, but you can imagine, this group of cops who, got a tremendously important job. He's got that mission there are a few more important missions than, policing, protecting children. I get the end focus. Yeah, you can see how it happens, but
at the very least,
we need these systems, right?
Yeah, at the very least, you can see, because I'm sure they're well intended, those people as well. But
exactly.
At the very least, you can see that it creates blind spots if you think about that information.
The blind spot. Exactly.
Yeah.
Exactly.
So slightly adjacent kind of topic that I wanted to segue into, which is really again about kind of emerging technology, emerging technology and government's kind of appetite for going there with digital voting. And so we've seen, in the same way with facial recognition, we've seen kind of governments wanting to kind of push towards digital voting. We've got a federal election coming out this year, but obviously state election in New South Wales, and our I say our, being a New South Welshman, Minister for Digital Dominello has been very proactive in spruiking electronic voting. But we've had some developments.
We have. It's another good example. Like you say, it's a good example of that, like, focus on the shiny future and not think about the complexities and all the work that needs to go on to get to that shiny future. The New South Wales iVote system, which I'm not familiar with as a Victorian, but online digital voting system was used for local government elections late last year, and it blew up. It crashed, and an unknown number of people were locked out and unable to place a vote. Which is, concerning.
Again, it's like the title thing with the committee. It's like, well, this is first post. It's like, let's let them in and let them vote.
You had one
at
job.
least.
It's in the name. I vote. Yeah. And so, which, if it's in the example of, like, that Minister Dominello like to bring up about horse racing, right? If a horse racing website goes down, you can't place a bet. Okay, great. Fine. Some people lost some money. The website lost some money. A bet wasn't placed. A vote wasn't placed. But in the context of an election, that's a real problem. So the New South Wales Electoral Commission, later investigating the incident, suggested that up to 6 elections could have been impacted by the glitch. Which I think they came to as, by analysing, the number of votes that may have been lost or missed, and whether or not that could have influenced the actual outcome of the election. And there was an associated or a second analysis done by a former academic, I think, and consultants, Vanessa Teague and Andrew Conway, who do a lot of work in this kind of cryptography and safe elections kind of work, that suggested almost up to a quarter of the elections of the 122 local council elections, up to a quarter of those could potentially have been tipped or gone either way, based on the number of votes and the amount of time that the system was down, and the votes that were lost, which is just startling. I mean, the idea, this is the basis of our democracy, the idea that that such a large proportion of votes and elections in a local council election could have gone away. And this is the system that they were planning on using for the state election. So, thankfully, I think good news or sensible news coming out of that is that those plans to use that system for the upcoming state election have been shelved. That the system needs extensive reconfiguration and testing, which is maybe an understatement. But yeah,
I think it's it's a good outcome. I think it's potentially caught a bit late. Like people have been, some of those names you mentioned have been raising the concerns for a long time, and seemingly without them being recognised until until just now when they've made this decision. It's a bit kind of counterintuitive with government. You often think governments are going to be a laggard with technology, but we see with things like with electronic voting, with facial recognition, there's a sense almost that it's the other way around, where like we wish they'd take more time. Same with some of the national security legislation that passed late last year. There was a lot of the independents saying didn't get time to kind of read the bill, and so with some of these kind of very important measures, we wish they would take more time, understand the risks, and understand how to put in the right safeguards before we kind of go ahead and do these things, which have, at least in the case of digital voting, immense repercussions on public trust in our democracy, as you say, and to say nothing of the potential impact if we actually had an election and there was a result, and then it was later found that a certain number of votes weren't counted or allowed to be counted, and what that would mean. So it's a good result in the end, but I think the broader sort of trend we're seeing around some of these technologies, I think, is a bit worrying.
Yeah, it is, and it's a real shame, because a lot of these things, I mean, voting in particular, there's a lot of expertise, and there's a lot of it's not a new problem, and the good point that you made just a moment ago is that these, the iVote system it wasn't a surprise that it fell over. People have been warning about this for some time. There's been a lot of issues about just funding it and sufficiently and addressing issues raised in the design. It's some of these, it's nice to see now that it seems like some caution is being applied here after such a disaster. But yeah, it's a worrying trend, right? The desire to rush forward to the new and shiny future when there are very legitimate concerns.
Yeah, and as we said before, why would you pass up the democracy chance for a democracy sausage. I mean,
Exactly right.
that's
Yeah.
also, you know, that's also what's at stake here. But yeah,
Maybe
look,
that's the problem.
yeah, I think that's definitely the
maybe
problem for
that's
you.
my issue, right? Like
Yeah,
I'm
yeah,
opposed to all this newfangled voting,
yeah.
newfangled ways of voting, because I just want,
You
I
want
want
your
my sausage.
democracy sausage.
Exactly.
If Bunnings ever goes completely online, they'll be
Yeah,
able to
yeah,
pay
it'll be,
you.
yeah, exactly.
You can't get a sausage on a Saturday at the hardware store. Well, that
Yeah,
was great, Jordan. I enjoyed that.
yeah,
Good
good chat.
conversation. Looking forward to next time.
Yeah, let's do it again next week.
Cool. See you, mate. Bye.
See ya.